Well, joining me now, we have Amy Sweezy, former assistant Hennepin County prosecutor, and Harry Litman, former U.S. attorney and host of the Talking Feds podcast. Welcome back to the broadcast, both of you. So, Amy, MS Now sources say the premise of the investigation into Governor Walz and Mayor Frey is a statute which makes it a crime to commit a conspiracy to impede or injure an officer. Does the DOJ have a case here?
Well, thank you for having me on, Alex. Appreciate being with you. I don't think so. That statute that would requires the conspiracy would require a number of things. The first would be an agreement between the mayor and the governor to have conspired to impede federal law enforcement and to do so with threats or violence. And it just doesn't appear that what we've seen from either Governor Walz or Mayor Frey is anything other than them exercising not only their First Amendment rights, but their obligations as elected leaders in the state of Minnesota. There's some reporting, of course, that there have been grand jury subpoenas. And I think one of the interesting things is, although it's commonly thought that grand jury indictments are easy to get, this Justice Department has had recent experience where grand juries actually are not indicting for things like that. So it'll be interesting to see what happens here, but it doesn't look like criminal activity to me by any stretch.
So, Harry, I want you to hear how Deputy Attorney General Todd Blanche described his concerns with the actions of Minnesota's leadership. Let's play that.
When the governor or the mayor threaten our officers, when the mayor suggests that he's encouraging citizens to call 911 when they see ICE officers, that is very close to a federal crime.
Blanche says their actions are very close to a federal crime, Harry. Do you expect they will be charged, or is this a scare tactic?
I think they will not be charged, but if they are, it won't go forward. As my colleague said, you got to have threats, force, or intimidation. That would have to be the theory, that somehow Walz and Frey are intimidating citizens. And under the First Amendment, you have to have it be imminent force. It would essentially be something like forcing them to lay down and impede federal law enforcement. I think it's a complete non-starter, and they know it's a non-starter. I don't even think it will proceed to a potentially embarrassing grand jury, but it could. The bigger point, though, Alex, is they've right now issued a subpoena. That is easy to do and only requires the local agents to do it. And will they have a chance to sort of forage in the files of Frey and Walz? But all of it, I think, is fairly corrupt is not too strong a word, because it's using a charge that is clearly meritless in order to fight a political battle that it seems to me the administration as of now is losing. So that's in some ways even worse than the reprisal prosecutions that we've seen from him to date.
But, Harry, can I just ask you to weigh in on, I mean, it just seems kind of bizarre what Todd Blanche said, the last part. He's saying that is very close to a federal crime. I mean, either it is a federal crime or it isn't a federal crime, right?
Well, and there is that, of course, and he's played a very unusual role for a deputy attorney general, a kind of cheerleader for Donald Trump. He's the one who said there's no basis for even investigating the shooting by Jonathan Ross. But yes, you're right. There is a, huge sort of deniability cushion in saying close to or exhorting. Look, you just heard what Tom Homan said. It's all about rhetoric, and we've heard that's all been public. Walz and Frey have said Minnesotans should exercise their constitutional rights and do it peacefully. 99+% are doing exactly that. No possible crime, and also extremely irresponsible for the federal government to assert that it's anywhere near the line. This is, as Representative Omar just said, what elected officials do. It's, that in the Trump world, if you oppose anything he's doing, including these pretty brutal tactics, that makes you a criminal, but not, fortunately, under the law of the land.
So in a ruling yesterday, a federal judge restricted immigration agents' actions against protesters, saying they cannot retaliate against people engaging in peaceful and unobstructive protest activity, at least for now. Notably, the case was brought before the fatal shooting of Renee Good, Amy. So isn't it already illegal for law enforcement to retaliate against peaceful protesters, or is there something novel about this ruling?
That's a really good question. I think that yes, it is unlawful for federal authorities to retaliate against people who are protesting peacefully. But it bears repeating, and in the context of the lawsuit and in the context of what we're seeing here in Minneapolis, I think it's a good reminder from another branch of government that that things can be outside the scope of what federal law enforcement is authorized to do. And for the most part, I think the judge's ruling, at least here in Minneapolis, is being met with a great deal of relief and just sort of a validation that that somebody else recognizes that they're not allowed to retaliate against peaceful protesters.
So the New York Times is out with new analysis of the shooting, saying slowing down the video contests claims that Agent Ross was run over. Let's watch.
Looking more closely, we can see in multiple angles that there's a visible gap between the vehicle and his legs, indicating his feet are positioned outside the SUV's path. The agent's left hand is still against the vehicle and gripping his phone. We see as he fires, it's recording the clouds and the trees overhead. It's not because the agent is knocked to the ground. The other angle shows he's still standing, continuing to maintain his grip on his phone and his gun, and we see a clear and growing gap between his body and the SUV as he fires a second shot and a third.
I'm going to ask you both to answer this question. Amy, you first. Is public evidence beginning to shape what happened in those few quick moments before Renee Good was killed? And how can this be used in court? Amy?
Well, that's another really good question. The video obviously is very, very important evidence. Any video is in any criminal case or any criminal investigation. And what the New York Times did by syncing up the video, if the Minnesota Bureau of Criminal Apprehension were involved in leading this investigation, I can guarantee that that's exactly what they would be doing, which is syncing up the video. I think it certainly adds a helpful dimension to it, but public evidence, as you've described it, would be very different from how this video would be received and viewed in court under the rules of evidence. For example, there wouldn't be commentary with the video, and the things that the reporter concludes, which has obvious journalistic value, would be exactly the things that a jury would be expected to find. For example, one of the things that the reporter mentions at one point is you can't tell whether the officer is sliding back because of the ice, but it's probably the ice. That's exactly the kind of thing, the granular details that a jury or a fact finder would be trying to find out. So the evidence is, of course, very, very valuable. What it shapes in terms of a public narrative could very well end up being different from what a jury would see in a hypothetical courtroom should there be a prosecution or a civil proceeding here.
Okay. Harry, quickly, last word to you on this.
Yeah, no, I'm not sure that look, they would see the video, and one of the things that's so valuable, this is exactly what prosecutors should be doing now. I spoke with Keith Ellison this morning. It's what they are doing, not saying he's guilty, but putting it together. But a really important part of this case, especially if the feds continue to impede state efforts, is if you take multiple videos, as the Times did here, and juxtapose them, they become something of a substitute for a well-analyzed single video. And that's going to be the core of the case. And in terms of the presentations of it, that's something that lawyers or even experts will be able to argue to the jury that can conclude on its own whether they find them persuasive.
Okay. Amy Sweezey, Harry Litman, thank you both so much. Okay.